Yes, he did say he's attending. Yeah.
Okay, people are filing in. Let's give it 3 minutes.
We can always have fun together.
I'm gonna put my video off now.
Sure.
Okay.
Sure.
Oh, and when Moshen, when you are speaking, I can just take off my video, right? That's cool.
Yes,
When
of
you're
course, whatever. Yes, no, that's fine. No problem at all.
Awesome.
Nice to be able to put a face to the, or faces to the names.
I know.
Yes. Mm. Oh. But you know Aaron, of course, right?
Yes. Aaron and I are good mates, so I do know him. Yeah.
Okay.
I think we've got, okay, there's 40 people here. I think we can start. It's recording. Okay. Cool. Bye.
Thanks, Ellie. Hi, everyone, and welcome to this afternoon's seminar with Dr. Moshen Al-Attar on decolonization, Africa, and international law, 2 frames of epistemic violence. My name is Victoria Collis-Buthelezi. I'm one of the PIs with the Other Universals program. Or consortium rather. I'm just going to go through a quick, give you a quick bit of info on Other Universals. Then I'll read Dr. Al-Attar's biography, hand over to him. We ask that for Q&A or questions, you can either put it in the Q&A chat, or you can raise your hand when we get to that time, and I'll identify you. Try to keep those set out questions as brief as possible so that everyone has an opportunity, or as concise as possible, so everyone has an opportunity, and greetings can go in the chat. So Other Universals, Thinking Politics and Aesthetics from Post-Colonial Locations is a supranational project supported by the Andrew W. Mellon Foundation. It is convened by the Center for Humanities Research at the University of Cape Town. The project creates a consortium of scholars across universities in South Africa, UWC, UCT, and the Witwatersrand, Ethiopia through the University of Addis Ababa, the Middle East at the American University of Beirut, the University of the West Indies, Cave Hill campus in the Caribbean, and the University of Ghana, Legon in West Africa. Dr. Moshen Al-Attar is an associate professor at the University of Warwick and a visiting lecturer at UCL and Beijing Foreign Studies University. He researches the role of international law in redressing and exacerbating economic divisions between regions of the world. Professor Al-Attar is best known for his writings on third world approaches to international law, a theory that guides his investigations into global political economy. In his forthcoming book with Oxford University Press, A Gorilla at The Hague, he argues that many of the principles of international economic law preserve a Eurocentric epistemology that favors a parochial view of human development and human flourishing. He's a permanent contributor to the international law blog, Opinio Juris, and is published widely in a range of journals, including Law and Critique, the Asian Journal of International Law, the McGill Law Review, the Palestine Yearbook of International Law, and the International Community Law Review. Join me in welcoming him.
Great, thank you for that introduction, Victoria. So I'm delighted to be here, and I'd like to open with a bit of a joke. I lived in Ireland for a number of years, and if there's something that I appreciate about the Irish, it is their sense of humor, a little irreverent, a little bit salty. And there's one joke, I believe, that encapsulates or captures very well then the topic of today's talk. Woman number one walks up to woman number two on the street and asks her, what is the best way to get to the post office? Woman number two pauses, reflects on it, and then says to her, I wouldn't begin from here, and walks off. Now, there are two important lessons then I find for this joke. The very first one is one that is relevant to me as an Egyptian. Egypt is mostly desert, for those of you who know, or those of you who don't know. Egypt is mostly a desert, and so it behooves every child to learn a little bit about desert navigation. And so, of course, when in the desert, when everything looks roughly the same, one necessarily looks up, where things can be a little bit different. And when you look up, you're able to see where you are. And then you might be able to figure out where you've come from and then be able to pinpoint where you're headed, in which case you can then plot an itinerary. And so this is very important in terms of our two Irish ladies. How do you get from point A to point B? Well, what is the starting point of decolonization? Where are we then in relation to decolonization? And do we have a destination in mind? Now, there's a second lesson as well, and this one you might even say is epistemological. Notice how woman number one is committed to the destination, getting to the post office. And notice how woman number two draws our attention away from the destination and towards, on one hand, the starting point, on the other hand, towards the journey itself. And what I really take away from this gag is that knowledge is subjective. And when we privilege one form of knowledge, we're usually doing so at the expense of another, or perhaps several others. Now I'll explore both of these lessons then on trajectories, then in epistemologies. I'll explore both of these lessons in relation to decolonization, international law, a little bit around then pedagogy as well. And I'll explore both of these lessons in 5 parts. So I'll begin by setting out what I would refer to as the epistemic contours of colonialism, but of colonialism as a world-making project. I'll then move on to the second part where I'll describe international law as a technology in this project. I'll say a little bit about international law's history and a little bit about how it operates. In the third part, I'll speak to you about decolonization, decolonizing international law, but from a critical perspective, representing it as a type of enclosure, a material enclosure, but also an epistemic enclosure. And then in the fourth part, I will present an alternative view of decolonizing international law. This is informed, I'd like to believe, by other universals. And then I'll conclude with a little bit on Dubois, some of you refer to as Dubois, and Dubois' ideas on radical consciousness and its implications for international law. The talk itself should probably take about 35 to 40 minutes, which would leave us then with plenty of time for discussions. Now, let me open by saying that colonialism was or is depending on perspective, a world-making project. And if we go back to its origins, we see this as colonialism was very much an attempt to pass off European interests, European aspirations, and European epistemology as a form of theory. Now, Samir Amin has provided us with a fantastic critique of Eurocentrism, and the essence of his argument is that Eurocentrism is not a genuine theory. It does not attempt to explain how the world operates. It doesn't seek to predict any patterns of behavior, but instead it seeks to force certain patterns, to inculcate a way of thinking. And it does through the power of faux science, as he calls it, of ideology, and of course of violence. And so when looking at colonialism, the logic of colonial rule was largely one of hegemony, an instance where we had European subjectivity posing as a form of human objectivity. Now, the dynamics of colonialism we see are pervasive. They've imbued the different forms of organization, the different forms of governance, the different forms of normativity across world order, and they've done so in a couple of ways. Now, on one hand, what we see then is what's sometimes referred to as external colonialism. This is the material. And within the context of international law, we sometimes describe it as a form of expropriation. I prefer to think of it as a form of enclosure. the material enclosure of all things within the circuits of capital. I sometimes refer to this as the economic productivity trap, and I'm sure many of you have heard this before. We evaluate, we assess, we gauge then virtually everything in our surroundings based upon their potential contribution to GDP. That economic productivity trap. Can we somehow fetishize the economic value of whatever it is that we're engaging? Now, that is an external form of colonialism. There is also an internal form of colonialism. And here I'm thinking very much of the perception of people, the perception of ecology, of nature, as some might say, within very narrow epistemic borders then that cohere with a colonial worldview. We could refer to this then as the theory of knowledge trap. And I recall my days in New Zealand. So when I was working in New Zealand, and as part of the introductory course that I would offer students, we would engage with the common law, we would engage with civil law, we would also engage with Islamic law, we would engage with tikanga. Tikanga is Maori law. And very interesting in terms of tikanga in the way they represent what we understand as nature, or what we refer to as nature. And so rocks would have legal personality. Waterways would have legal personality. We've seen this develop across then a number of South American states now under this new constitutionalism. It was very difficult then for many of the students who were not themselves we would say, fluent in Maori culture to appreciate how a waterway could have a legal personality. It's very difficult for, I suspect, some of the listeners today to appreciate that. But what we're saying then is that this is an internal form of colonialism that privileges one epistemology over ultimately many others. Now, both the external and the internal forms of colonialism will usually operate concurrently. In both instances, colonial powers would deploy what are effectively technologies of colonialism to naturalize, to legitimize what was, in essence, a Eurocentric view. And both material and epistemic colonialism are essential to the current world order. They have not gone away. And some of you are obviously familiar with the writings of Ngugi wa Thiong'o, who I'm always fond of quoting. And I particularly like his statement about the night of the gunboat being followed by the morning of the chalk and the blackboard. How important it was in educating people as to this particular worldview, ensuring that they inculcate this way of thinking. Now, both real or material and epistemic or symbolic forms of colonialism, then, these are epistemological in character. And what do I mean by that? I have to consider that with colonization and settler colonialism that followed, the aim was to make a place that was already inhabited their own. To make someone else's home yours does require some level of destruction. And here is where we saw efforts then undertaken towards disrupting the epistemological outlook of others, all done to advance then a colonial worldview, a colonial ordering. So when we speak of colonialism, it's important to center the idea of destruction. It is a story of destruction, of physical, of cultural, of epistemological genocide. Now, the challenge for us is that because we are largely, on one hand, inculcated in the world that colonialism birthed, we are also committed to that world. And it is that commitment that results in us trying to find ways to recast this destruction as a form of creation. And I'm thinking here in terms of religion, rights, industry, markets, technologies. Each one of these is leveraged to advance a positive, even benevolent view of the colonial project. Each is intended to legitimize the very exploitative colonial dynamics that are at the heart of our current socio-political order. And international law is one of these technologies within this project. Now that allows me to segue into the second part of today's talk. And I'd like to tell you say a few things then about international law. The global legal architecture itself is structured around, we could say loosely, 5 types of law. On the one hand, we have municipal law. So whatever political entity we have, whether it happens to be a tribe or a city state, or even a nation state, we think of the law that applies inward, internally then, to those within the jurisdiction of that political entity. Refer to that as municipal law. There's a second type. The second type, sometimes referred to as outer state law, so outward looking. The rules then that will apply beyond our borders. And so often people don't realize this, but the rules that a state will operate, what they operationalize within their borders, may not be the same as the ones that they will operate with beyond. And you can think of this in relation to the United States. And some years ago, Obama then ordered the assassination of an American citizen, and ordered his assassination while he was in, if I recall correctly, it was in Somalia. Now, interesting then, this assassination of an American citizen when they are outside of the United States. But could he have authorized that within the United States? Well, no, that would have been an ultra-virus act. But in this case, we're referring to outer state law rather than municipal law. Third type that we have is what we sometimes refer to as supranational law. Supranational law, the easiest example would be the European Union. European Union has a European Parliament, it has a European executive, it has a European judiciary. So we create a parallel system that consolidates a number of political entities. Fourth type, international law, internation, so between nations. Fifth type's transnational. This is the ultimate universal. We transcend nation states to create a truly global form of law. And so I wonder, and I'll put this to you now because I'll come back to it a little bit later, the African continental FTA, is this municipal? Is this outer state? Is it supranational? Is it international? Does it have any transnational aspirations? Now, within the modern order, what I hope some of you will have picked up on is that the state is primordial. All of these systems begin and end with the nation state. Now, this can cause a lot of confusion, and it causes a lot of confusion because the state is not natural. The state is not ontological. The state is contingent. The state is a cultural construct. And because it is a cultural construct, we can ultimately imbibe the state with whatever personality we wish. Now, what we see is the state use these different forms of law to formalize its preferences as these pertain to the regulation of behaviors, the regulation of activities, the regulation of relations. And so in this way, we often describe the law as being transactional. It is providing then a mechanism for ordering relations between legal actors. There's a transaction taking place and the law intervenes in mediating that transaction. But there's a second element to it. Where do we source these preferences? Well, the preferences are informed by our collective identity. And so the laws that we have in Egypt differ from the laws that we have in the UK in the same way they would differ from the laws we have in Mozambique and differ from the laws that we have in Singapore. They're informed by our collective identity. So just as the law is transactional, the law is also existential and shaped by local communities. And what we find within legal pedagogy, within legal education, is that this existential transactional dichotomy is often left out. It is absent. And to appreciate this dichotomy, I usually tell then students to consider 3 questions, and I put those to you today. The first one is a normative question. How do we choose to regulate our relations? Which behaviors or activities do we condemn? Which ones do we permit? That is a normative question. The second one is a political question. Who makes that decision? Is it Parliament? Is it the King? Is it the Queen? Right? Is it which judiciary, which branch of the judiciary, who decides? But then there is also a third question, a pragmatic one, and I only introduced this one very recently. But as a consequence of 1 and 2, the normative question and the political question, we might simply ask, who owes what and to whom? Who owes what and to whom? Now, all three of these questions are relevant for our understanding of international law and our understanding of decolonization. Now, when we discuss decolonizing international law, we could, as an aside, also talk about decolonizing municipal law or outer state law or transnational law, but for today's purposes, our focus is on international law. So when thinking about decolonizing international law, it's important that we come to some kind of agreement as to what international law even is. Now, on one hand, we can say it is a system of social order, and that to me largely makes sense. The world is made up of a series of sovereign states. Each of these sovereign states is equal, whether you happen to be the island of Vanuatu, well, you are equal then to the People's Republic of China. Irrespective of the size different, irrespective of the geography, the location, the demographics, a sovereign state is equal to another sovereign state. And so we agree then on these rules that will guide the behavior of sovereign states so as to establish a system of order. We might even say this is a bit of a bulwark against any type of chaos if we had all sovereign states operating from a place of self-interest. So that brings us to the second quality about international law. In addition to being a system of social order, it is also a mechanism of restraint. A sovereign state is sovereign, and there are no limits to sovereignty, except the limits that the sovereign self-imposes. And international law then acts as a limitation on a state's sovereignty. It is voluntary, based upon what we refer to as the doctrine of voluntarism. But these are usually seen as reciprocal restrictions on state behavior. State A agrees to restrict a particular behavior if state B does the same. And they codify that within a treaty within international law. Now, the type of commitments that they make are usually negative rather than positive. It's much easier to obtain a commitment to not do something than a commitment to achieve a particular objective. But regardless, what we see then is this type of reciprocity. So let's try that out based upon the three questions that I provided you with earlier. How do we regulate relations? Well, let's use an example, the Non-Proliferation Treaty. Now, it is the Non-Proliferation and Disarmament Treaty, but putting that aside for an instance, the Non-Proliferation Treaty. We agree then that we will no longer pursue the development of nuclear weapons, a negative duty. The disarmament has proven a little more challenging, largely because of that positive aspect. The second question then, who decides that we will no longer pursue the development of nuclear weapons? Is it the Security Council? Well, not really. Is it the General Assembly? No, it is not. It is the signatories to the treaty. So those states who voluntarily assent to limit their sovereignty. And then the question is, who owes what and to whom? Well, it is a reciprocal duty. Each one of us then is committing to the other that we will no longer pursue this form of technology. Now, this representation of international law as a system of social order, as a mechanism of restraint, is on some level quite benign. It seems fair, it seems balanced. All sovereign states have an equal say. It seems quite liberal, we might even say. But that representation of international law would be both ahistorical and acontextual, because there's a third quality, and this is international law as an instrument of domination. The transatlantic slave trade, conquest, occupation, settlement, all of these have taken place under the guise of international law. One of my favorite quotes from Tony Blair, I do have a favorite quote of Tony Blair, yes. One of my favorite quotes of Tony Blair is when he gave his non-apology for the transatlantic slave trade, for Britain's involvement in the transatlantic slave trade. And very interesting what he said, and I quote him, he said, "It's hard to believe that what today would be a crime against humanity was lawful at the time." What did Tony Blair mean by lawful? Lawful according to whom? Lawful according to the African communities who were abducted and then shipped across like cattle, right, to inhabit other parts of the world, to labor over, to toil over these agricultural products, these goods, to become then what was in essence then fodder for the growth of capitalism. Was it lawful according to them? Well, no, it was lawful according to Britain, because international law operated as an instrument of domination. And so here is where we see there were different questions that they were posing. It wasn't about how do we regulate relations and who decides, it was rather what can Europe obtain from others and how can the law help? And that is the basis of colonialism and the world order that ultimately colonial powers established. Now, let me say a couple of more things about international law before we shift into its decolonization. To better understand international law, we have to go back a little bit in time. You can either go back to the 16th century or to the 17th century, and historians, international legal historians, are somewhat split on this. Now, let me start with the 17th century, then, origin story of international law. It begins with an end, the end of the 30-Year War, the war between Catholics and Protestants. And it ended in what is known as the Peace and subsequently the Treaty of Westphalia. That treaty divided Europe into territorial units that we would henceforth refer to as sovereign states. And the main agreement within that treaty is that each state will refrain from interfering in the internal affairs of other states. And that is so transcendental in terms of human civilization that this remains the basis of the state system today. Control over territory, control over decisions, control over activities, behaviors, regulations, all of this was the prerogative and responsibility of the state in whichever form it took. Now, that is the beginning of international law according to some mainstream international legal historians. There were, of course, forms of international law that predate Westphalia. This is especially the case both in the African and Asian continents, but they're largely absent from the frame today and as a result, absent from the associated pedagogy. But there's another origin story, and this requires us to go a little further back and requires us to touch into or to dip into the 16th century, and we're going before Westphalia came Cristobal Colon, Christopher Columbus, came conquest, and Francisco de Vitoria. Now, Francisco de Vitoria had an interesting responsibility. He was a theologian then in the court of Isabel and Ferdinand. And Columbus, or Colon, however you say it, posed a question. After arriving in Hispaniola, he sent a letter to him, dispatched then a letter to Vitoria, asking him, what can I do with the natives? Or as he put it, the Indians. What can I do with the natives? And Vitoria goes into this long explanation about the nature of the law of peoples, or jus gentium, which came to be known as the law of nations. And he highlighted 3 rights and 3 responsibilities: the right, the freedom to settle, the freedom to trade, and the freedom to proselytize. Now, these were not Spanish laws. These were not European laws. These were laws in nature. And they bound the Spaniards in much the same way as they bound the natives and vice versa. To Vitoria, the natives were then vital to the story, because it is their lands that the Spanish were ultimately going to settle. It was their resources that they would extract or trade for, as he saw it, and it was their souls that the Spanish would ultimately save. And what's very interesting about Vittoria is what he says Columbus can do if they resist, if they don't allow their lands to be settled, if they don't allow for their resources, for him to extract their resources, or don't provide an audience for their conversion. And what he speaks of is enslavement and genocide. It's actually in the materials, the enslavement and genocide for resisting what the law of nature demands of them. So the natives were vital to this origin story of international law, but they were also irrelevant. The territories found outside of Europe were largely regarded as terra nullius, belonging to no one. And yet, because the natives, even though the natives did not have sovereignty over their lands, they could not have sovereignty over their lands. They could, however, sign contracts or treaties with European powers that granted Europeans exclusive trading rights. And this formed the basis then of relations between the colonies and the metropoles for the coming generations. And so what we see then is that the international law that emerged in the 16th and 17th century was contradictory. Natives or non-Europeans were not sovereign over their lands, but were sovereign over their international relations. Which is why I say what I said earlier about the question that Europe asked itself at the time: what can Europe obtain from others, and how will law help them? Now, as we know from the historical record, Europeans ultimately settled the lands of others, plundered them of resources and of people, and in some instances established puppet governments to rule on their behalf, and so on and so forth. Again, that story is well trodden. What is less recognized, or at least beyond then this sort of narrow sphere of critical international legal scholars, is that many of today's international legal questions pertain to the status of these activities, of their legacies. So let me just give you a few examples. There is a doctrine known as uti possidetis, the doctrine of uti possidetis. What does this doctrine tell us? That we are to preserve the borders that were established by colonial powers post-decolonization. So after a state decolonizes, the borders, right, persist. Now, this is a very interesting, then, doctrine. It's a very interesting doctrine that was developed largely to deal with the African problem. And as many of you know, when we look at the history then of Africa, we effectively had European powers in Berlin in 1884 take a map of the continent and then, almost with a ruler and pen, cut it up into a piece of graph paper. And by segmenting it as such, we necessarily crossed over different societies, different waterways, different communities, different families, and such. Well, international law tells us that irrespective then of that original sin, even once these societies decolonize, the borders are valid, with all the problems that arise as a result. Another example would be the Vienna Convention. The Vienna Convention speaks to us about then the commitments that a state has made, the international commitments, and how these then will persist even after there is a change in government, even after there is a change in state. So the question, of course, is those puppet governments that we mentioned earlier that were established to advance colonial rule, they assented to many different treaties. Are the subsequent societies bound by those treaties that they assented to? Well, according to the Vienna Convention, they are. The theories of statehood. Some of you might be familiar with the Montevideo Convention, 1933. Montevideo Convention sets forward then a theory of statehood, the criteria for a people to ascend to the status of a state. Most interesting about that is the date, 1933. And as many of then the participants in today's talk will recognize, much of our continent was still colonized at that time. So are we as Africans bound by these theories of statehood that developed and that did not involve us in any which way? And finally, my favorite one, the principle of intertemporality. Principle of intertemporality. Now, this one sounds quite reasonable. We will only assess a legal question based on the laws that are in effect at the relevant time. Now, again, that sounds reasonable. How can we hold someone liable for a law that wasn't in place at the time? But go back to what Tony Blair said. The UK doesn't need to apologize for slavery. It can express regret, but it doesn't need to apologize. And it can't be held accountable for its role in the transatlantic slave trade because it was lawful at the time. Does this mean that within international law, there is no legal mechanism for holding then colonial powers accountable for the historical violence that they perpetrated and in many instances continue to benefit from? Can no one be held accountable for the genocide of the Herero and the Nama? So go back to what I said to you before in terms of those three questions. How do we regulate relations? Who decides? Who owes what and to whom? For international law, the answers are largely what Europe preferred during its colonial period. Those are the answers that we must work with because that is what is codified in law. And so international law becomes a very useful then frame for understanding the universalizing thrust behind a Eurocentric epistemology. Now recall Fanon, right? Colonialism was a total project. There was no part of the human person, no part of human societies that were left untouched. And so I return then to my Irish joke. Seeing how central colonialism is to modernity, what is the starting point of decolonization? Now, this brings me to the third part of today's talk. Decolonization must be layered, and it must be layered because, again, as Fanon pointed out, as Ngugi pointed out, colonialism conquered lands, cultures, minds, epistemologies. Material expropriation, external colonialism. Internal colonialism, epistemic destruction. International law was an instrument to advance both the material and the epistemic. The doctrine of utiposiditis, theories of statehood, principles of intertemporality, as I mentioned earlier. And there's a fantastic line from Sundhya Pahuja, wrote a book entitled Decolonizing International Law. And she describes the third world as having been born into law. Born into law. Fascinating then thinking about what the implications are of that. Well, the implications to me are largely Gramscian. We have organized consent around a colonial system of world ordering. And this has an impact necessarily in how we come to understand decolonization. What form of decolonization strategy is appropriate when dealing with this type of system? Now, within the International Legal Academy, the decolonization agenda has largely been one to make the social order a little more palatable. And so we introduce new writers, we introduce then new worldviews, but we never really call into question any of the foundations. This is a type of mainstreaming of decolonization. I'm sure many of you have read Tuck and Yang. We include some critical perspectives, we add some counter narratives, sprinkle a little bit of social justice. So we challenge the law without challenging the presumptions. And in this way, decolonization, and I direct you to the title of today's talk, in this way, decolonization becomes another form of epistemic violence. And I say this, in fact, because of the inclusion. The inclusion of decolonization within the agenda of the International Legal Academy results in a type of epistemic enclosure. We permit decolonization within the established parameters. You can decolonize your state so long as you retain the borders. You can decolonize your society so long as you respect the treaties that you've already committed to. But it's not just inclusion as a form of epistemic enclosure. It's also inclusion as a form of epistemic foreclosure. We are delineating the type of change international law will tolerate. And so in this way, decolonization, as it was represented during the time of Fanon, is ultimately co-opted. There is a desire to preserve the unequal order, largely because we're unwilling to confront the sacrifice needed to actually decolonize. In the context of international law, there are a number of tropes that are deployed to challenge the argument that I'm making to you now. Sometimes referred to as nihilistic. I had one colleague tell me that the other day. Another one has said idealistic, utopian as well. And then there's the third one, of course, which is the baby and the bathwater metaphor, which I'm sure many of you have heard. We're not going to toss the baby out with the bathwater. And I recall very recently, this was a short while ago, one of my TWAIL colleagues asked me, after having read some of my latest scholarship, they said to me, okay, so I take it you've abandoned international law altogether. And I understood why they framed it in that way, because in one of their own pieces of scholarship, they had written that the third world cannot abandon international law as others will not. And so we ourselves must learn to, we must become expert, adept at utilizing international law to our advantage. I believe that argument is fallacious. I believe it's also simplistic, at least in the way it was referenced to me, and I believe it's also violent. The role of international law, the role of all law, is ultimately to preserve the status quo, and it will often do so under the guise of a faux rationalism, a faux universalism. Now, it's not going to be just about the status quo. We do allow for slight amendments. Then we can play around at the periphery. But what we cannot accept is the wholesale subversion of the system. Yet this is the problem then for international law and the debate around, pardon me, around decolonization. Some aspects of decolonization are irreconcilable with the current order. As Tuck and Yang say, incommensurable. I'll give a few examples in the next part. But what I want to conclude this section with is making mention of Kuhn's scientific revolutions. We have on the one hand, cumulative research, and cumulative research, while useful, is about preserving the commitments that we've already made. Revolutionary research is different. And in this case, this is the challenge for decolonization in international law, is that even those who are seeking to decolonize want to do so in a cumulative fashion. And so this brings me then to the penultimate part of today's talk. What might a revolutionary approach to decolonizing international law look like? Now, I'd like to say that it must begin with a new creation story. And recall what I said earlier about colonization being a story of destruction. And so we must pursue a new story, a new creation. And what does that look like? Well, I'd like to say that there are a few options for how we could pursue this form of decolonization. Again, a focus on international law. Now, on the one hand, it could be decolonization as redistribution. If the basis of colonization was plunder, was exploitation, was expropriation, then a redistribution of the resources, of the proceeds makes sense. So, for example, right, an immediate cancellation of third world debt. That would be a fantastic way of redistributing then the wealth. Consider the second one, decolonization as reparations, atoning for the injuries suffered, the injuries sustained. Now, some of you might be familiar with, and if you're not, you should familiarize yourselves with CARICOM's 10-point plan for reparatory justice. It's a very interesting settlement that they propose as a way of dealing then with the barbarism associated with colonization. And after looking at CARICOM's 10-point plan, have a look at the settlement between Germany and the Herero and the Nama. Germany, right, many people here will recognize, ultimately then committed genocide against the Herero and the Nama in the early 20th century. Fascinating that they trialed many of their techniques that they ultimately used against fellow Europeans, against Africans first. Very interesting to have a look at the settlement here and some of the statements made by Germany at the time when they were negotiating the settlement about where they wanted the money to go and where they didn't want the compensation to go. Because of course, Germany must have a say over that. So take a look at CARICOM's 10-point plan. Take a look at the settlement then achieved between the Herero and the Nama and Germany, and see decolonization as a form of reparations. Or perhaps we might consider decolonization as restitution. Acknowledge the immorality of cultural appropriation, of cultural theft. Think about all of the cultural artifacts that were looted from third world societies. How long did it take then for Lumumba's tooth to be restituted? How long did it take for Maori to claim back the bones of their elders that were stored in a museum in Scotland? How much of the British Museum belongs to my people, belongs to Egyptians? And what about decolonization as a form of repatriation? As Tuck and Yang point out, colonization is ongoing. There are some obvious examples. These include Palestine. There are disputed lands in Aotearoa or New Zealand, in Canada, in Australia. There have been some attempts at this repatriation. Of course, we followed with interest what took place in Zimbabwe. We also followed with interest then the judgment of the International Court of Justice in relation to the Chagos Islands. Is that a form of decolonization that the International Legal Academy could get behind? Now, notice what I deliberately did not say. I did not present decolonization as a form of reconciliation. That R I left out. And I left out reconciliation deliberately because reconciliation can only happen between equals. And until we're willing to admit that Europe not only profited, but profits from a colonial construct, until we're willing to recognize the immorality of this arrangement, there is no reconciliation possible. Which leads me then to the final part of today's talk, and what I refer to as decolonization as renewal, or as Dubois said, rehumanization. Dubois, fantastic writer, fantastic thinker, founder of critical race studies, founder of critical white studies, quite the revolutionary. One of the concepts he developed is the double consciousness, or the notion of double consciousness. And if I quote, he said, where he wrote, "It is a peculiar sensation, this double consciousness, this sense of always looking at oneself through the eyes of others." The colonized pursue decolonization, but they often do so within a colonial epistemic. And just as colonizers are conditioned by this epistemic hierarchy, so too are the colonized. And yet, while we inhabit a colonial or possess a colonial consciousness, we also have our own reality. Hence the double consciousness and what is sometimes a taboo among scholars of decolonization. The extent to which we have internalized colonial ideas about legality, normativity, epistemology, and of course, decolonization. And now I'm going to quote from one of my own articles. And this was a statement that was made by what some might regard as a critical scholar of international law in describing the international legal system. And they wrote, "However unfair and skewed international law's history was, an international legal system exists. Any other system built to mediate the interests of hostile states would look very much the same. Any other system would look very much the same." Now, this is a peculiar statement. It is a peculiar statement because it suggests there is a type of universal epistemology in operation. It is a peculiar statement because it is ahistorical. And as I said to you before, prior to the Westphalian system of international law, we also had a number of African systems and a number of Asian systems. So it's very possible then to simply dig through the historical records to confront a series of international legal systems that do not at all look like the one that is on offer today. But there is that internalization that has taken place. And according to Dubois, we must convert our double consciousness into a radical consciousness that is grounded in other universals, in other epistemologies. And so we would then counter that dehumanization of colonialism by rehumanizing ourselves. Now, I've asked myself what a radical consciousness would look like in the context of international law or international legal research, international legal education. I have a forthcoming article in Law and Critique, one that I co-authored with a colleague, Claire Smith. This is on international economic law and racial capitalism. And what Claire and I do is make use of the Black radical tradition. And we use this to critique the approach adopted by international economic law scholars, particularly the critical ones. Well, what is the Black radical tradition? Why is it relevant to this debate? Why is whiteness, or why has whiteness been exercised from our discussions about international law? And what contribution could Blackness make to our understanding, our thinking about international law? Now, Claire and I recognize these are provocative questions. They're provocative questions that force us to think about epistemic violence on one hand, and about epistemological equivalency on another. And at the moment, I'm working through another piece, and this one has been was inspired by another colleague, Babatunde Fagbayibo. And this one I'm writing about the FTA, so Africans Continental Free Trade Agreement, and Africology. And I wonder, when I problematize, will we embrace neoliberalism as it's encouraged by the WTO, or will we develop an African approach to international economic law? One that seeks to further this ambition of decolonization, of rehumanization. And if so, what does that even look like? And one example then, if we think in terms of European philosophy, I'm sure all of you have heard the expression, I think, therefore I am, going back to Descartes. But what about if we were to approach international law from an African perspective? Because we've already tried the European liberalism approach, focusing on the individual, focusing on the state. I think, therefore I am. It's very much about me. But from an African perspective, I am because of who we are. I am because of who we are. That is more of a collectivist approach, a communitarian approach. How would that influence law? Is this relevant to our thinking then about the FTA? And of course, this has implications for how we understand decolonization. Once we begin to ask those questions, what can African philosophy contribute to international law? We reject the faux universalism of Eurocentrism, and we embrace the prospect of other universals. We're also rejecting that cumulative approach towards research, a cumulative approach that keeps us bound within what is effectively a parochial epistemic frame, and embracing then what could be a radical revolutionary one. Now, this brings me to my conclusion. And my conclusion is, some might say a little skeptical, some might say a little cynical. I like to think of it as a tad more provocative. The decolonization of international law is a long way off. Fanon, decolonization sets out to change the world, but we set out to change the world because the current world order publicizes itself in human misery for the vast majority of the planet's peoples. Europe was founded on the exploitation of others and continues to benefit from it. The colonization, exclusion, immiseration of others is pretty good business. And I find that within debates about decolonization, this predatory characteristic of the relationship is often left out of the conversation. We even see across Europe and across the International Legal Academy, largely a denial of the benefits of colonization, and certainly a denial of the colonial legacies. We could even say that the myth of the self-made state continues then to grip the hearts of many. Now, Samir Amin referred to these as the partial truths of modernity. Decolonization makes these partial truths evident. Decolonization helps us improve how we think about law, but also how we think about political economy, how we think about epistemology. Colonialism was a world-making project. It was an attempt to pass off European subjectivity as human objectivity. The story of colonialism is one of disruption, of conquest, of destruction that took place both materially and epistemologically. International law was a key technology within this project, with Europe often asking itself what it could obtain from others. Now, to legitimize what it ultimately did, that expropriation and that destruction came to be represented as benevolent. And so international law has proven central in universalizing a Eurocentric epistemic. And so once again, and one last time, I return to that Irish joke. What is the starting point of decolonization? To me, the answer is obvious: other universals. Is there a destination? Well, I'd like to think ideally it is a world where we are not careening towards our own destruction. And how will we get there? I'll answer that with another question. How will Africa, how will Africans rehumanize the world? Thank you.
Thank you so much for that. You really took us across the globe and to different questions and conversations that we've been having in other universals, Moshen. There are a few questions coming in, so I'm going to read these first two. Dr. Kenneth Cannell, great talk. How has the current pandemic and the evolving inequity of public health access influenced TWAL, and more importantly, vice versa? Annika Maurer, This was a very enriching talk. Great speaker. Thank you so much. Could you provide any additional resources at the end of the talk? Is there a paper I could read up further and can share?
All right, so to the first one, thank you, Dr. Connell, for that question. How has the current pandemic influenced TWAIL? Did I get that one right then, Victoria? Yes, I'll assume I
you did.
say that again.
You did. That's the question.
Excellent, excellent. Thank you. So very interesting that you bring that one up, Dr. Connell. And I wonder in terms of the type of reassessment. It's hard to say whether it's influenced TWAIL per se, largely because that critique of the inequalities, TWAIL scholars have been making this then for a couple of generations now, and making this critique about the inequalities in relation then to a variety of experiences, of endowments, of opportunities, of access. Now, this has largely brought it to the front in terms of front and center, and seeing this then, particularly around vaccines. And there was a push then by a number of TWAIL scholars, but also other critical scholars, then to effectively break the patents that we had over then the vaccines to make it accessible. And I believe, I'm sure that you can tell us this a little bit, you have the numbers here, but when we were looking at the level of vaccination within Europe, we were seeing pretty high numbers, anywhere between 70 and 85%. But when we were looking across the African continent, we were languishing at less than 10%. And so obviously severe inequalities there, cost related, also production related, distribution related. But what it came to then is very much just a privileging then of one part of the world over the others. So I'm probably less interested in what TWAIL has to say about the inequalities and more about the ways that the third world went about addressing this. And so what we've seen then was China develop its own vaccine, Cuba develop its own vaccine, and then make this available to other third world societies. Very fascinating then to see that type of, I don't want to refer to it as philanthropy, I prefer the term solidarity. So that type of medical solidarity developing across the third world. And obviously Cuba has a long history of this medical solidarity, but certainly it was very good to see China come in as well in its own way. And so will TWAIL scholars take up this debate? I think they already have in relation to intellectual property, and there's a long running critique of the approach towards IP, an approach then that privileges obviously then those who are already front runners in terms of technology. But I believe we also have Titi Adebola in the call, and she might be able to chime in on this as she was central then to the advance of that, that debate around then the vaccine. Additional resources, yeah, it's an easy one. I am happy to plug into the chat box if I can do so before people begin to exit, a few articles, a few suggestions, things that you might read. You can also just visit my SSRN page. I have a few articles in which I've written about this, or you can just contact me via email and I'll be happy to share those with you.
We have a few more. And we can also, I'm assuming we can put your website in the chat. I can do that for you while you go through the next set of questions. So Brenda Combo, thank you very much for this fascinating talk. My question is about the African Continental Free Trade Area. To what extent do you think there is room, given the legal architecture that has been created by the WTO, for African states to take an African approach to trade without being sanctioned or facing other legal challenges? Diteko Modesane, I'm just going to read those three. So that was Brenda Combos. Diteko asks, confronting the painful traumatic results of colonization and its violence presents a big challenge. If it was possible for Europe to embark on world making through violence, what kind of conditions can we imagine to undo it? In other words, can we speak to think through violence and its alternative as conditions for decolonizing international law, etc.? Aaron Kamagisha, fantastic talk. I was fascinated by the discussion of Victoria, the Spanish jurist who I've encountered only tangentially. I was wondering if you have any thoughts on the slightly later debate on the status of Native people between Bartolomé de las Casas and Sepúlveda at Valladolid in 1550. This debate is increasingly being recognized as a major debate in the history of political thought. Has this debate had any resonance in the field of international law?
Excellent then. So let me deal with the third question first. Thanks, Professor Kamagisha. I appreciate that question. And in fact, if I can direct both you and then listeners who are interested in that to the article, an article that I've written on decolonization, and I refer to that as, with my co-author, Shaima Abdel Karim, we refer to that as entrapments in praxis. And we engage directly with Las Casas and Sepúlveda in terms of their debate. And we actually link it then to Vitoria. So I think of all the people, all the listeners here, Professor Kamagisha, you're probably the one who's going to enjoy that one the most. Then I'll take the first question on the FTA. So can we adopt an African approach while at the same time then avoiding sanctions? So it's a fascinating question, and it's one of the challenges in relation to international economic law. And so for those who study international economic law, this will be a bit of a primer, and for those who don't, this will be an introduction. There are two doctrines within international economic law that make it difficult for us to develop an African approach towards the regime. What's known as national treatment and most favored nation. And the most favored nation doctrine is the most challenging of all. What the most favored nation doctrine tells us is that if you were to provide any type of preferential treatments to one member of the WTO, then you must extend that same privilege to many others. Now, the challenge then is, of course, that we're looking regionally because of a shared history, because of a shared geography, because of shared inequalities. We're looking then for ways then to support one another in advancing a common cause. Well, unfortunately, then the architecture of international economic law is set up in a way to limit that possibility. There's meant to be this type of universalization, this type of equality then that comes from the system. So we will treat all equally. But the challenge to that is, of course, that it's a formal equality that we're privileging. When we see the substantive inequalities, then of course it makes sense that we would have things such as special and differential treatment, which we have had historically within the international economic legal system, that does provide then a little bit of leeway in terms of developing an African approach. But the part that I've left out of today's talk, and I'll direct everyone to a second article then possibly to consider this, is the place of capitalism within the framework. Capitalism is ultimately the system then that we are committing to via the FTA. And so long as we commit then to a capitalist form of logic, then we're committing to different forms of exploitation. And that is the essence of the international economic legal system. It is the regulatory regime for global capitalism. And so in terms of epistemic, both enclosure and foreclosure, capitalism is the elephant in the room. And I always find it unfortunate that we don't engage with this. And when I gave a talk on decolonization some time ago, one of my colleagues who teaches international economic law asked me how I went about decolonizing my teaching of international economic law. And I said, well, I teach my students about capitalism, and I teach them how the outcomes that we see today are inevitable within a capitalist economic framework. And so the limits that we have are not so much established because of the WTO, but they're established, in part they are, but they're established mostly because of the economic frame that we are now wedded to. And to the final question, which was the middle one, the confronting then this painful legacies of colonialism, can we undo violence? Yeah, that's a fascinating question. And it's a fascinating question because of the very narrow understanding I think we have of violence. And I think about this both within the popular imaginary, but then also within a lot of scholarship. Now, what is taking place across the African continent, even when it comes then to the vaccine, the inequality in relation to the vaccine distribution, that is an acute form of violence that we might say that Pfizer or that the AstraZeneca or that these various companies are doing to our society, but we might also say that it's something that Europe is doing to us. It is violence then to deny people what are essential life chances. But we often don't think of violence in those terms. We think of violence more through the lens of gunboats and such. And so when it comes to undoing the violence, I think the first step is achieving that awareness that this is a form of violence that a society is perpetrating against others. And people are very reluctant to see that, largely because of the guilt that can result from it, and what Tuck and Yang have described as the move to innocence. So once we feel that guilt, the desire is not so much to remedy the conditions then that have produced the guilt, but rather to alleviate the guilt itself. And so we engage in these various plays to find a way to alleviate our suffering, so it becomes about us. So if you haven't read that piece by Tuck and Yang, Decolonization is Not a Metaphor, please do, it's well worthwhile. And they do touch upon this. You'll see that I distinguish myself from Tuck and Yang in a few areas, but mostly what I'll say then to the participant who asked the question, I think it requires us to take a more nuanced understanding of violence. And once we adopt that more nuanced understanding, there becomes the possibility of imagining that renewal, that rehumanization that can take societies or civilization forward without relying on that element of coercion that is all too prominent in world order today.
Thanks for that. So we have a few questions. I'm gonna give you another 3. And then there's one in the next round that I want to piggyback on. So this is a very enriching talk. My question is with regard to the problem of failing states. What does the Twale approach say with regard to the principle of sovereignty and interdependency in the international scenario? From Batayehu Demli, this is an eye-opening, great talk. Thanks a lot. Is global law the same as transnational law? And does the decolonization pedagogy have a preferred substitute term for international law? Zerihun Wodeselasi, what do you think about the need, challenges, and prospect of solidarity among Africans, both at state and societal levels vis-a-vis decolonization?
Right, okay, so these are excellent questions. And I understand why Victoria chose them. So first one with regards to failing states, I probably have to take issue with that qualifier in terms of failing. I live in the UK and it certainly feels like a failure to me. So I wonder then, what are the metrics that we're utilizing to distinguish between successful states and failing states? So I challenge that then, but putting that element aside and addressing the second part of your question, what did Twale say about sovereignty and about interdependence? Well, on the interdependent side, this is what is interesting about international law. Interdependence is the basis of, or effectively the impetus behind, the international legal system. And we say that the world is interdependent. And so we can simply think about the cotton shirt that I'm wearing now. Well, the cotton that I'm wearing now, where was it grown? Well, in this case, it's a case of Egyptian cotton. I'm a bit of a nationalist, but it could have been grown in Mexico. It could have been grown in the south of the United States. It could have been grown in China. It could have been grown in the upper parts of the African continent, and that's about it. but everyone wears cotton and everybody wants to wear cotton because of the nature of the fabric. So what we're dealing with then is an interdependent world. There are many resources then that are exclusive to some regions and others that are exclusive to other ones. And with that in mind, that interdependence is meant to encourage us to pursue a type of cooperation, collaboration, maybe even solidarity. But of course, we're doing that in the context of a capitalist system that favors, that you might even say, then ultimately operationalizes self-interest. That is the driving force between capitalism. It is ways that I can maximize my self-interest. We might even say that we're weaponizing self-interest. So how then do we reconcile this competitive then ethos with that interdependence? And the answer is not very well. Now, there have been proposals within Twale scholarship for a more nuanced approach towards sovereignty, but this is usually done as a way of extending it beyond the nation state, as a way to do justice to indigenous peoples, who are obviously then at the forefront of the decolonization debate. That's the challenge, though, because it requires us to rethink what we mean by the nation state. And I don't see either political or popular will towards that. And I do wonder, and this would then lead me into the third question that was posed on African solidarity. Now, you might say that I'm a Pan-Africanist at times. At other times, I try not to identify then with a particular, then not being nationalistic or Pan-Africanist, and then trying then to pursue that type of rehumanization that Dubois encouraged. And that requires us necessarily thinking beyond borders. And I start thinking about what the African continent could pursue. Is this an opportunity for this type of epistemic renewal? Can we effectively dream big and go beyond then the parameters of what is been imposed upon us? On one hand, I think of Marx, and Marx says that we make history, but we do not make them then of our choosing. We effectively have to operate within the conditions then that we face. So I don't know if that's possible. Second, you know, there is quite a bit of fragmentation across the African continent. So I think about even, you know, this would be a funny example, but the AFCON and Egypt lost to Senegal. Congratulations to Senegal, they outplayed Egypt, but I was really quite ashamed when I saw the Egyptian team walk off the pitch before Senegal even received their medals. And so, yes, this is just a case of sport, but that type of competitiveness, that type of antagonism that we see between Africa and other parts of the world also takes place from an intra-African perspective, sometimes even more so. We could think of Nigeria and Ghana, we could think of South Africa, and we could see then that those larger African states that have much to lose from the advance of a united Africa, much to lose economically, then might resist it in some way. And so then I don't know if we're at the point where we're even capable of thinking in terms of rehumanization. We can't even think about then just facilitating visa-free movement across the continent. So there are the moments there where I feel optimistic and excited and positive, and there are other moments where I say the challenge then is colossal, because we want people to rethink how we've ordered the world, and we very much internalized then that colonial project. Which then brings me to the final question, which was the second one, on global law and transnational law. I would encourage you probably not to worry so much. I know I utilized that then earlier where I was referencing that, and these were just terms that I was making use of to facilitate the understanding for the non-legal scholars in the room. But really what the focus is not so much if we want a substitute term for international law. And it's one of the challenges that we face. So I've taught international law for a number of years at a number of universities at a variety of continents. And every time I'm teaching international law, but the thing about teaching international law is that we're teaching European international law. And it is only in this past year that I've started to see a handful of scholars refer to it, that system, as European international law. And when we are trying to teach the others of it, the other universals, then we might say, well, then you're teaching Islamic international law, or third world approaches to international law, or Asian approaches to international law. And I wonder what it means then when we qualify it. And I wrote about this in an article, must international legal pedagogy remain Eurocentric? And that is one of the problems that I identify. Students are already reluctant to take international law because they don't see necessarily then the professional value of that course. They can assure you that they will not take a course entitled African Approaches to International Law if there is international law on offer, because the international law itself has greater legitimacy than the way that we describe it. So from a TWAIL perspective, what we are trying to do is to make the debate, you might say, a little more inclusive, or some of us are pushing this decolonization agenda, which goes beyond then simply subjecting students to readings or materials that are written by non-Europeans, and goes to questioning then the very foundations of the system. Now, that in itself can be a very enlivening, but at the same time, it can often act like a sledgehammer to the chest for our students, because they hear this and then they think, okay, well, international law is a mess, I might as well abandon that. When really what we're discussing then is a type of renewal, and renewal, of course, takes time.
Thank you for that. So I am going to press on. We have quite a few more questions. I'm going to try to tie some together. Ivan Collinson, dear Professor Attar, that talk was amazing. Congratulations. So good to hear from you. I wonder, how do you relate your thoughts to what Professor Olufemi Taiwo says when he states at some point decolonizers themselves are disregarding, infantilizing, and imposing values on contemporary African thinkers? From Daniel Arboleda, the critiques of TWAIL are practically the same as the ones formulated against critical legal studies, nihilistic, idealistic, etc., but they often come from a superficial knowledge of critical theory. However, there is one rather, in quotes, positive question coming from minority scholars that seems to apply in the international sphere. They say, and I quote, academics want to destroy law because they barely use it. Law would be essential for minorities to protect their rights. Wouldn't it apply to international law? We, the weak nations, need international law to, for instance, protect ourselves from Western interventions in virtue of sovereign equality and non-intervention principle. The third question I'm going to offer you this round is from Ruchi Chakraverty, another of our PIs in Other Universals. Thanks from me too for a rich and provocative talk. To pose a question about your question, what might Africa in particular have to contribute to the rehumanization process? And how do you grapple with what some colleagues have called the weaponization of decolonization? For instance, in India, where Hindu nationalism is mobilizing the decolonization discourse for a violent, dehumanizing supremacist project. Now, there's another question that I think relates to this I'm just going to put on here, and this is from Simon Rakai, who thanks you for the talk. Simon, forgive me, I'm going to shorten this a bit. I'm thinking, for example, of Gary Wilder's Rethinking Decolonization in Freedom Time, where he thinks through Senghor and Césaire's decisions to choose departmentalization and not state sovereignty, thereby attempting to transcend and reinvent the idea of France. Do you think a similar approach might be possible for third world countries in international law as one way, for example, to answer the question of how Africa will rehumanize the world?
Excellent. You're not going easy on me, which is appreciated. And no, these are all these are fantastic questions, and I'm glad I've made note of them because I'm working on an article, and so a lot of this will find its way into them. Yes, Professor Onifume Taiwo, him and I had a brief correspondence about something related to this, very brief. Then he's not a friend or anything. I wish he were, but we don't know each other then. So the answer to that question is yes. There is a lot of, and you know, apologies then to colleagues out there, there is a lot of shabby decolonization scholarship out there. I'm sure many can make that critique of my own. What I find then in terms of the type of decolonization scholarship that we often see, it's the type then that Tuck and Yang are targeting in their piece from a decade ago. It's, you know, a little bit of that DEI scholarship, you know, diversity, equality, and inclusion. And it's suggesting this type of shared mutuality and a type of shared suffering, and we're all in this together because we're all colonized and such. And I do find that infantilizing in large part. Because of course, people recognize, and we need to go back to Dr. Connell's question from earlier on, we certainly recognize that we're not in this together. And many people do benefit from a colonial project, are continuing to benefit. And many of our colleagues within the academy do benefit from it as well. And it's the denial of those benefits in the same way that it happens both at the political level, at the popular level, also happens at the academic level. And so when we think in terms of decolonization, there is a lot then of shabby scholarship, but there's also a lot of promising scholarship as well. And it's that scholarship, as I say, that is not taking things then for granted, that does challenge a lot of the presumptions upon which then the current order rests. And they simply say that this is a contingent cultural construct, nothing more. And because of that contingency, there's no reason why we should feel any commitment to it. I admit I'm always amazed when I hear judges out of the United States or legal debate coming out of the United States, and they keep referring to the framers this and the framers that. And I always can't help but laugh and think, but who cares what the framers said? The commitment then to the system that we have today is not a commitment based upon any type of obligation, but rather because this is the system that we want. And the instance we say that this is no longer the system that we want, well, we challenge that commitment that we've made and we start to think of a new approach. That to me is where the potential for liberation arises. And it's more of that type of scholarship that I would want to see. The critique of TWAIL is often based on superficial knowledge of it. I think you're right. I think that is the case. Did CLS have a nihilistic thread to it? Certainly some critical race theorists have said as much. I'm less familiar with CLS, and so I'm probably not willing to take a position on that. I do recognize that some of their scholarship does come across as nihilistic. And again, because I rate critical race theorists as much as I do see value. I do see then that I suspect that their critique is in itself valid. I've read a number of critiques. I'm working on a book on TWAIL, so I've obviously read the critiques of TWAIL, and some of these are valid as well. I myself have put out a couple of critiques on TWAIL, one in which I refer to it as a paradox within a paradox. And the argument then is that international law is a paradox, and TWAIL is thus paradoxical in the way that it critiques it. So on the one hand, and this comes to your question, on the one hand, we effectively bludgeon it from beginning to end for its colonial history, from its colonial operation, from the exclusivity within which it has developed, with the full form of inclusion associated with it. And then in the end, we turn around and say, but it could be much more, and it could be a just system, and it could be this, and it could be that. And this is what I say is ultimately the paradox. And we haven't really thought a way beyond that. My sense is not so much that the paradox does a disservice to TWAIL, because I take the point that you've made. You've got Professor Tony Angie at NUS who's made that argument, Professor Bhupinder Chimney, recently retired, who's made that argument. We cannot give up international law, because if you don't do international law will do you. And we've seen a number of SIDS, small island developing states, really then utilize international law to their advantage. So it's not so much about abandoning it altogether as to recognizing the intrinsic limitations to the framework and starting to think beyond it. So on the one hand, we have those who can pursue that type of cumulative research that Kuhn encourages, but effectively what the critique is, we have to see more of that revolutionary type of research. We have to start thinking about it differently, largely because of one of the final comments I made about us effectively careening towards our own self-destruction. And we're certainly aware of this across the African continent, and certainly there are a number of third world states where we think of the consequences of the increase in rising, or the rise in temperatures is going to be cataclysmic for our societies. My own country, Egypt, is already dealing with a water shortage. Forget about the dam coming out then in Ethiopia. We're already dealing with a water shortage. We're already dealing with a drought. We're mostly desert. We have very little arable land, and we have a population of 100 million. Increase the temperature by a couple of degrees, and I can assure you that there will be many of us swimming across the Mediterranean, which means there will be consequences for others. So yes, international law does have some value in, on some level, preventing some of the worst excesses of Europe. And at the same time, it has, of course, failed outright and requires us to move beyond it. What might, and then the weaponization of decolonization. So what might an African form of rehumanization look like? Yeah, I didn't have a feeling that would come up, but it has been on my mind. And it has been on my mind because what we can see via some of the debates around decolonization is a type of nativism, a type of essentialism emerge. And certainly that is the case in India. And that nativism is in itself violent, that nativism is exclusionary, and that nativism is designed in a way that, to me, doesn't in any way advance what we understand by decolonization, but instead advances some of those original approaches towards nativism that we would have seen closer to the 18th and the 19th century. So it seems to be more consistent with the past than it is with the future. And so I think ultimately it's important for us to distinguish between what is academic debate and then what is political posturing. And a lot of what we see coming out of India, in the same way we see coming out of a variety of places, the UK included, is that political posturing. The US and that hate that they have then for CRT. A lot of this is never born then of the scholarship itself. It is always born of how that can be weaponized to advance a particular political aim. And I think if we didn't have decolonization on the table, it would be something else, because rather these are agenda outcome driven operators who are looking for ways to advance a type of populist cause. So I don't think that in any way delegitimizes the decolonization debate. I think it simply then puts us on notice that we're going to continue having a rough ride. To the final question, I think what I might say, I might answer it with an article then that some of you are, I'm sure, are familiar with, and by an author that you're certainly familiar with as well, Makau Matua. So Makau Matua wrote an article back in 1995 entitled, "Why Redraw the Map of Africa?" And it's a very interesting piece. He didn't build upon that. I asked him about it at a dinner in Joburg some years ago. And I asked him why he didn't build upon it. And Matua, being as irreverent as he always was, didn't give me any kind of a straight answer. And I wasn't sure if it meant then that he was disavowing some of the ideas contained within that piece, or he just felt that it was a non-starter politically, and maybe he was already eyeing some kind of a political career at that point. But regardless, what I appreciated about that article is effectively the radicalism within it. And not radicalism for radicalism's sake, but radicalism in the sense of problematizing what is a core challenge for our continent. And the core challenge is that we're trying to adapt then effectively to borders that bear no logical sense. And we have to operate with this because we now have that commitment to these borders, despite the fact that it can produce severe then shortcomings to the way we organize ourselves politically, economically, socially, and such. So I appreciate radical revolutionary scholarship mostly because it provokes us to think differently. And I'm a big believer then in that provocative thought, largely because we don't know where we're going to end up. All that we can say is we don't especially like the way we are, and continuing to develop scholarship in the way that we're doing is merely continuing to take us down the same trajectory. And so a type of why redraw the map of Africa requires us to break from our thinking and maybe begin to reconceptualize the problems, which can then help us get a little bit closer to that renewal, rehumanization that we aspire to. I'll leave it there.
Thank you for that. So I'm going to, it's that the talk has been so provocative and provocative in all the best ways in terms of getting everyone's brains churning and thinking through these problems and questions. So there are, I think, two sets of questions on the table in a way. And the first set, I think, get into the sort of ecological Anthropocene. So I'm going to pose those. I also would like to maybe abuse my position as chair a little bit and ask you at some point to speak to the what I think you sort of pushed us to consider around reconciliation versus some of the other R's, such as reparations, restitution that you raised, and the question of human rights. So I'm going to piggy that onto this set of questions. Vanessa Ludwig has great presentation, thoroughly enjoyed it. Thank you. You mentioned that Maori law was not anthropocentric. Other indigenous cultures have similar ontologies. Do you think one of the reasons we remain captured within systems that continue to privilege European epistemologies is because we have adopted an anthropocentric approach to decolonization? And then I think there's another question here, maybe even two, but Sir, from Prajwal Vasuki. Sir, what is your opinion with regard to introduction of ecocide or ecocide as an actionable crime in the International Criminal Court, and how exactly would it impact the capitalist approach to international relations and globalization? Just to give you a heads up, I think the next set of questions have to lean into the question of statehood, reparations. So I'll put that set, and then I think we can stop after that round. This has been phenomenal. If anyone has any other questions, I think you can contact offline. So it's this set of questions, then I'll pose the next set, and then I think that'll be your opportunity to close. Thank you, Moshen.
Great, thank you, Victoria. Just to be clear, I've got the first one on whether or not we've been captured by an anthropocentric approach to decolonization. The second one, my thoughts on ecocide. You had mentioned yourself, Victoria, something around reconciliation and rights, but I'm not sure if you posed the question or if you were just giving me heads up that you were going to pose that question. I
wanted to ask you if that's something you wanted to sort of speak to a bit more, especially given it's an international audience, but I kept thinking of South Africa and the South African question and how reconciliation plays out. And you spoke about the problem of reconciliation without coming from equal footing.
Okay, and so I would expand on that one. Okay, got it then. All right, so thank you for those questions. So the short answer to the first question is one of the challenges we face in relation to decolonization, the fact that we've adopted an anthropocentric approach. Yeah, one among many would be the short answer there. One among many. There are many problems with it. I do appreciate then on the first hand, I do appreciate then, and coming at it from this epistemological equivalency approach and saying that, so what do I mean when I say epistemological equivalency? So we think in terms of theories of knowledge, and theories of knowledge, then we can come at it from a variety of perspectives. Would you come at it then from an Islamic perspective? Would you come at it from a Chinese perspective? Would you come at it then from an African perspective? And what does that even mean? Or do we come at it from what we now refer to as a historical perspective or the international perspective? And what Eurocentrism has done has largely been to capture the narrative. And effectively, then it holds the middle ground. And we could think about then Ngugi and moving the center. So trying to treat then those other universals not as peripheral, but rather than as other universals that may be able to put forward another view of how we should connect to ourselves, to the ecology that we're a part of, in ways then that are more attractive, that are more appetizing than what is currently on offer. And certainly what we see from a number of indigenous systems is this rejection of this anthropocentric approach. Well, it's not so much a rejection of it, is that they simply don't conceptualize it in that way. And we saw with these new constitutionalisms coming out of Ecuador was one of them, Bolivia was another, right? There is a Brazilian scholar by the name of Enrique Afonso Vale, who's writing about these new constitutionalisms. Very interesting to see the approach that they're taking, where they're trying to provide a type of legal personality then, and really what their legal personality to nature. And really what they're doing is simply introducing then an indigenous episteme into their understanding of constitutional rights. Now, that fusion could have some potential, but the challenge with it is something then that was alluded to by you and also by the subsequent question, or by the subsequent participant who asked the question about ecocide and the extent to which it could restrain capitalism. We still remain committed to an idea then of nature as property. And so if we treat water and land and the fruits of the land as property, and yet at the same time, we are endowing then that same water and land with legal personality, then what we're creating then is a conflict between these identities. And then as a result, there is necessarily going to emerge a hierarchy between them. And so at some point, one of the greatest challenges that we will have to confront is our commitment to property itself. And there's a great book by Brenna Bandar then on, I believe it's titled The Colonial Afterlives of Property. And really interesting to think about how this conception of property that emerged from the UK in a particular period in time, 17th, 18th century, how we've universalized that conception of property that forces then this anthropocentric outlook on life that again takes us then towards our own destruction. And so, yes, I think our commitment to an anthropocentric approach is one of the shortcomings, but that commitment is born not because of the nature of decolonization, but because of the nature of the dominant epistemology that we are operating within. Which then takes me to the question about ecocide. So I understand then the motivation behind it. And I'm sure you can pick up from my hesitation that I'm not endorsing it. I understand the motivation behind it. It's one of my colleagues at UCL, Philippe Sands, he was one of the champions of it. And there were a few others, and another one of my colleagues who writes on Opinio Juris has written some very interesting critiques, Kevin Heller. You might want to read some of his work on ecocide. Part of the challenge I find with ecocide, and why I don't think it'll be effective in restraining capitalism in any which way, is that it is consistent with a desire to juridify human relations. And so we want to then be able to say, this type of behavior is permissible, this type of behavior is prohibited, and anybody who engages in this type of behavior will then have to suffer these type of consequences, and we'll have a neutral judiciary that will be there to mediate the dispute, so on and so forth. In the same way that we've juridified trade, so now no longer trade is a matter of diplomacy, it's rather handled then either by the dispute panel at the WTO or by private arbitration bodies. It's the same way to try to represent, then to try to protect our ecosystem via then the same failed regime. And so it's an attempt once again to preserve capitalism while at the same time giving the illusion that there is some type of redress within this capital frame that is feasible, that is viable, and that could potentially be effective. And I find again, and this is why I go back to the answer to the comment I made earlier, how do you decolonize international economic law? Well, you decolonize it by teaching students about capitalism, because they don't realize, most of them don't study capitalism at all at any stage of their primary, secondary, or tertiary education. And as a result, don't appreciate that the outcomes that we see today were inevitable within a capitalist system. And so it is that commitment to capitalism that ultimately ensures that we'll continue then careening down the same trajectory that we find ourselves on now. And I don't think ecocide is going to put on the brakes on that at all. So finally, to Victoria's question about reconciliation. I said this one in passing, and I said it in passing largely because of the transitional justice movement. And a lot of Chepo's work is relevant to my thinking on this. There's an Irishman by the name of Brendan Brown, an Irish scholar by the name of Brendan Brown, who's written about this, and I rely on his work as well. Very interesting then when there's the way in which they critique transitional justice that is all based upon these ideas of reconciliation. And the absence of any type of equality between the participants ultimately results in what are often nefarious, even say violent outcomes. And they're violent outcomes because the people who are brought together are at an imbalance. There is one who is then ultimately asked to atone for their wrongs without actually atoning then for their wrongs. And so in that instance, reconciliation is not really on the table. Really what they're asking for, and this again, Tuck and Yang, it's that move to innocence. They're merely looking to feel better about then the situation, the privileges that they enjoy, the benefits that they enjoy without surrendering any of that privilege or benefits. And so I don't really engage so much with reconciliation at this point. I say, once we've had the restitution, once we've had the reparations, once we've had these different forms of genuine decolonization, then at that point, I think we can have a conversation about reconciliation. But until then, you effectively still have your boot on my neck. And in that instance, there's not really anything for us to reconcile. You're not looking for reconciliation. You're really just looking then for a type of salvation for yourself. So I'll leave it at that.
Thank you for that. So as I said before, folks, this is the last round that I'm going to read. If you have more questions, feel free to either reach out through other universals or directly. I think we did post Professor Al-Attar's website, so I'm sure you can get hold of him otherwise. So this last round of questions, I think, takes us squarely into some of what your talk addressed in terms of the statehood, and particularly in terms of the Middle East, and I think Africa and the Caribbean. So any idea on a stateless nation self-determination rights in international law, such as the Kurdish case in the Middle East. Provocative talk, thank you. How do you think lawyers in colonized states, countries, especially Palestine, can decolonize its legal systems when facilitating the recent colonial laws are essential to provide short-term protective measures? For example, I have to give legitimacy to Israeli law when pleading before an Israeli court in order to get a Palestinian political prisoner out of jail. I have to refer to UNICTRAL and ICSID conventions in order to dissolve an economic restraint on Palestinian business persons, entities under the allegation of terrorism. I have to plead before Israeli tribunals to prevent arbitrary destruction of Palestinian houses and property. How do we deal with this dilemma? And then you have John Denanio. Thank you for such an insightful presentation. What do you make of the argument that Africa and the Caribbean have failed to claim reparation due to how they frame the reparation claim processes? Reference is made to successful claims made by the Jews in respect to how they frame their claim to the Germans. And then I think, what is your opinion on, well, you spoke to reconciliation, but I'll read the question from Rusa Nangolo. What is your opinion on reconciliation and pending reparations of Hereros and Nama genocide?
Findy, before you go, sorry, Victoria, before you go, can you repeat the first one on the statelessness? I didn't really catch the question.
Okay, let's see. That question is, any idea on a stateless nation, so nation without state, self-determination rights in international law, such as the Kurdish case in the Middle East?
Right, got it. Okay. Excellent. All right. Thank you for that, Victoria. Then, okay. So yeah, really tough questions once more. So when you say any ideas on the stateless nation, so really interesting one then, no. If we think then in terms of the establishment of the United Nations, 1940s, established largely then by the victors of then this Second World War or Great European War, however you prefer to term it, established the United Nations, pushed then by the Americas, something of a push then by African states, at least indirectly and such. And the idea then is that we wanted something different. And then when we look at the charter, there's a number of protections there that were devised specifically with the colonies and anti-colonial resistance in mind. Self-determination is one of them. Self-determination does have some type of radical then potential. But it comes to how do we understand then that self-determination and how do we ultimately actualize it? So in the case of that stateless nation, when you're referring to the Kurds, and I'm thinking of Turkey and I'm thinking of Iraq, what you ultimately have is what is a secessionist movement within a state. And there is that element of self-determination. And if that group is strong enough, and in fact, if the nation state is weak enough, then there can be a comfortable middle ground that they ultimately reach. I don't know if that is nearly necessarily a case for the actualization of self-determination, or if this is merely then the results of a political reality. So what we see then would be, if we were to think about it a little bit more, you could look at Maori within, again, Aotearoa or New Zealand. You could look at some of the indigenous groups within Canada, or certainly the United States, and even again, some of the indigenous peoples then in Bolivia and Ecuador and such. And to what extent do they enjoy self-determination? Well, the development of what we mean by self-determination is quite wide and rich. And we see then that these different communities are pursuing self-determination in different ways. Some are looking for a type of outright, as we say, secession, and others are looking for something that is merely a recognition of their special status. So there is great potential for that self-determination, depending on how it's ultimately mediated. And what we've seen to date is because of the notion of sovereignty and the inviolability of sovereignty, then it's mediated in a hierarchical manner where ultimately self-determination comes second to sovereignty. So long as it does not disrupt sovereignty, then self-determination for a stateless nation is possible, but that might not in fact be what that stateless people want, which is why we might want to start thinking beyond the nation state. And people hear that and they think, well, that's quite radical. But if you say the nation state has only been around for some 20 generations, not really that long. Prior to that, we didn't organize the world in nation states. It's not to say that it's coming to an end anytime soon, but certainly we can see pushes in both directions for that kind of nativism and the strengthening of borders, but at the same time for a push against it. And where does Africa fit in this model? Well, time will tell. Next, Palestine. Yeah, Palestine is its own special case, and there are some other places then that have inherited a number of colonial laws. And you could think of any type of settler colonial society as largely inherited, whether it's the civil system from the French, the Spanish, the Portuguese, the Italians, the Germans, or they've inherited it then, or even the Dutch, or they've inherited the common law system then from the English. And all of those are ultimately intertwined then within their systems. Palestine is a special case, and Palestine is a special case because it hasn't inherited any single law. There are some, then you might say, organic laws, Palestinian laws, but then of course you also have the Israeli laws, and then you also have your English laws, and then you have some Ottoman laws, and then you of course have these international commitments. But is Palestine really a nation state that has made these commitments or not? Well, it's still bound by jus cogens, and the list goes on and on. So what you end up having then is something of a pastiche, a mosaic then of laws that ultimately act upon the Palestinian people. All of this under the nature of occupation, which should normally trigger the Geneva Conventions and so on and so forth. So quite a complex picture. So when you say to me, how do you decolonize under that? Well, the thing is that settler colonialism is still alive and well in Palestine. And so I imagine if I were thinking about it, I would defer then to the Palestinian scholars on this. I would imagine that at least a starting point in relation to this is at least a challenge to that settler colonization before we start thinking about redoing then the legal framework in Palestine. You would have to get past that continuing settler colonialism, an end to the occupation, then a type of sovereign status with its borders ultimately respected then by Israel, before you could even start to have a conversation about what type of a legal system you would then take forward. And you could look at some of these smaller states out there that have done something similar. So if you were to look across the Caribbean, again, you have a pastiche of laws, largely because of all the many different colonial powers that had intervened within the Caribbean. But then you also have an attempt to develop type of domestic laws. Then whether this is happening through CARICOM, whether this has happened then, and we could think of the individual states, but there has been an attempt to, you might say, indigenize the legal systems. Of course, that is going to draw upon then the legal systems that are in place, but we can see a type of hybrid emerging. What happens in the case of Palestine? Again, first off, we have to deal with the occupation before you can get to decolonizing the legal system. Have Africa and the Caribbean made a mistake in how they've approached reparations? Right. That presupposes that there was actually at any point any willingness on the part of Europe towards reparations. I know a few scholars who reject the idea of reparations altogether. One in particular, I remember he said this to me. He said, they're never going to give it to us anyway, so why bother? And I thought, well, there are reasons to bother. And the reasons to bother are often to make the argument, to make the case, because it keeps the spotlight on it. And I recall David Cameron traveling to Jamaica And I'm sure, again, some of the listeners will be familiar with this story. David Cameron travels to Jamaica, and he's confronted by the Prime Minister on reparations, and he says he doesn't think that's an important conversation to take place today. Instead, he wants to talk about trade, and lo and behold, the UK wants to invest 25 million pounds in Jamaica. Fantastic. They want to build a supermax prison for the people they will deport from the UK so that Jamaica can house them in Kingston. So that is the nature of the relationship that often takes place between the metropolis and the former colonies. It still remains hierarchical, it still remains racialized, it still remains violent. So with that in mind, I don't believe then that reparations was ever genuinely on the table. And until it is genuinely on the table, then what we continue then is as unequals trying to make then demands that are falling on deaf ears, and it's sort of the world continues to turn and we continue to hold our hand out. And so I much prefer the type of collaboration that we're seeing these days across the African continent between the African and the Caribbean. As I said, a little bit more of that third world solidarity. Not to say that we shouldn't continue to push then the reparations agenda, certainly not. But, you know, I'm trying to think the sight of the Vice Chancellor then of University of West Indies running around with his hands out, begging for handouts from a variety of universities in the UK is somewhat shameful and probably doesn't in any way, to me, cohere with that type of rehumanization that we would want to see. And finally, then, what do I think of the reconciliation between the Herero and the Nama and the Germans? My biggest bugbear with what took place between the Germans in terms of the reparations was the demands that the Germans placed in terms of how they were to spend the money. Now, it wasn't exactly tide aid in the American style, but it was designed in a way that would, you might say, cohere with German understanding of their responsibility for the genocide that they committed. And that to me is somewhat distasteful. Now, I try to imagine, and you were comparing it with the reparations that were provided then to the Jews by the German as well. Well, there was a very different approach then. And one wonders, in the same way that Cameron spoke to the Jamaicans, if there was then that racialized narrative flowing into the conversation between the Germans and the people they had massacred. So there is a different approach then that, of course, Europeans take towards other Europeans, and there's a very different approach when they take towards, in what they adopt towards former colonies. This much is obvious to us. And so the reconciliation to me can only, as I said before, happen once we have reached that point of a type of equivalency, recognizing then that I am sitting at this table not as a way to forgive you, but rather because I feel that it's important for me to sit at this table, and I'm willing then, right, to allow this conversation to take place. And some gratitude and appreciation on the Germans' part because of the genocide that they committed. That to me is an essential starting point. But again, in the same way that Cameron had the conversation with the Jamaicans, in the same way that Tony Blair tells us that it's hard to believe that enslaving people was lawful, so on and so forth, there still remains that resistance to the idea then that their societies have benefited in any way from colonialism, from slavery, from genocide. I don't see us getting to that point anytime soon, which is why I very much encourage us to pursue that type of intra-African solidarity that can produce the rehumanization that can then extend to other parts of the world. I'll leave it there. Thank you.
Sorry about that. Thank you so much, Dr. Moshen Al-Attar. This was a phenomenal evening, afternoon, midday, wherever you are around the globe. We appreciate it. Folks, please check out the links provided in the chat and reach out if you have more questions. Much appreciation for giving us this time and engaging our questions. Thank you.
It was my pleasure. Thank you for having me. I was delighted to be a part of this event.
Thank you. Ali, I think we stop recording now, right? So we'll just give folks an opportunity to check out those links. But otherwise, we're off.
Okay, I'll add one more link then. I have, I guess, if there's anyone still there, some of my blog posts are sometimes more accessible. Let's see here. There we go. Well, there are a few people there. So let me go ahead and put that in the chat box. There we are. Like that. Victoria, is it possible to get a copy of the questions that
Yes, I believe we will provide those. I think we can provide those. We have them with the recording in the chat. Pindi, is Ali on? Can he confirm that, or can you confirm that for us?
Yeah, I would think it will be provided. Ali doesn't seem to be here. He would be the best person to answer that, but I do think it will be provided because it is recording.
Okay, perfect.
Yeah. Excellent.
Yeah. Thank you so much, Professor Moshen.
No, it was a pleasure. Thanks to you again for the organization. Fantastic. I was delighted to be a part of this, and I look forward to attending your future events. I'll sign out now.
Thank you.
Bye.
Okay, I'll end it. Bye.